Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana. And today we will be covering segment 4 of the Stanford Trust Victims Trial against the Office of Financial Institutions, or OFI for short. And that will be the day's proceedings of Wednesday, July 31st. And this one should be considerably easier to do than yesterday's. Because there was only one witness, so we'll just call this the Sid Seymour Day, because he was the only witness. Mr. Seymour is semi-retired, having been basically, if you add the time he was actually with the OFI, plus the time since then, which is 4 years, that he has served in a contractual capacity as an advisor to the current Commissioner of Financial Institutions, you would be talking about 47 years. So this is not a Johnny-come-lately. He has been around a while. He was even asked his age on the stand. He said he's 73 years old. And he has been in on the trial from the beginning, and so that was beneficial in that he could attest that he'd already heard certain testimony to somewhat streamline the process. But having said that, I found nothing streamlined about it, and we'll cover that as we go into it. But so Mr. Seymour was originally hired on at the OFI in 1978, and he served as a field level examiner for 11 years, and then he was the chief examiner for the OFI from 1989 until 2020. At which point he retired and then took on this, consulting capacity. So that was 31 years as the chief examiner for the OFI. He had an accounting, he had two undergraduate degrees, and that one in personnel management, and then an accounting degree from Southern Miss. And they asked him, are you familiar with bank failures? And of course, anybody who's been with the OFI for that long, or the FDIC or anything, you're going to be familiar with bank failures. And he said, well, yes, we had a number of them in the 80s. I too experienced that. I worked at institutions that were at one point closed, closed for their own identity and brought back as something else, but that's ancient history now. But his point was, yes, I had we lived through a number of them in the 80s, but only 4 bank closures in the last 25 years. He was asked to explain to the jury the whole concept of a loan loss reserve, and that basically, in a nutshell, banks they need to make provision for potential losses on loans. When the FDIC comes in and does an examination, typically a loan will either be passed, which means that we didn't, I say we, as if I'm still with the FDIC, no problematic findings with that particular loan, or it may be classified substandard or potentially loss. If it is classified as substandard, a given percentage of that loan will need to be reserved for. Loss would mean it's 100%. Then, of course, once the loan is literally charged off, meaning it's deemed to be uncollectible, then you would credit against the loan loss reserve. Debit the loan loss reserve, credit the loan receivable for the amount of that charge off. It does not mean the bank throws in the towel on collection efforts. That if they manage to collect on a charged off loan, that's called a recovery, and you can reverse that back into the loan loss reserve. He gave a little bit more simplified explanation, but that's basically it. He also explained that beyond just state chartered banks, the OFI is also responsible for licensing and providing the regulatory guidelines for things such as finance companies, pawn shops, payday loans, etc. And there began to be questioning about whether or not these fees have dominated the discussions of just about every witness that's been up there. and that today was definitely no exception. And so what was basically going on is that the fees would be paid by Stanford International Bank, SIB, to Stanford Group, and then Stanford Group would turn around and make the payments into Stanford Trust. And so, the question was, or the issue that's at hand is whether or not that type of an arrangement was proper. And Mr. Seymour volunteered that the OFI had concerns about the whole arrangement, and so back in 2001, he said that he sought for Stanford Trust to obtain a private letter from the IRS that would, indicate that these were permissible. He said instead what we got were legal opinions, and he said for the time being we let that suffice. And let me just say this: there reached a point that the SPH, and I'm going to use that as an acronym for sidebars per hour, was really getting out of hand in the courtroom. I mean, you were lucky if you had 3 minutes go by without the need for a sidebar. I want to look. I have no idea how the jury is going to react to Mr. Price's style of trying to question witnesses. It is a mannerism and technique that I have not experienced from any other attorney in all of my watching of court observing. That's a lot. While I can't tell you how the jury may react to it, I can certainly speak for how I would react to it if I were on the jury, and the reaction would not be well. I find very frequently his line of questioning to be very abrasive, to be condescending, and I'll be blunt, a little bit obnoxious. That was, I think, easily the perception for the Phelps Dunbar attorneys, and they let Miss Needy, and we provided a link for the attorneys, and she handled everything today. Now she's relatively young. You'll see in her profile if you click on it, and so she's wanting to do things by the book, and especially in laying the foundation for the introduction of evidence and so forth. And I'm going to tread carefully on what I'm going to say. Well, I guess I've already let the cat out of the bag that Mr. Price he's not getting the answers he wants, and he is accusatory of Mr. Seymour of just not answering the questions. Well, when you're only allowed to get 2 words out of your mouth and you're being told that you need to answer my question, that's obnoxious, okay? Now, everyone knows an attorney wants a yes or no answer, and then you're welcome to elaborate. Well, there were questions being asked that were simply not yes or no questions, and I thought Mr. Seymour did a great job of once this whole, and this became not very friendly. I mean, Mr. Seymour never came across as unfriendly, but Mr. Price was clearly irritated, and it showed, and so Mr. Seymour at one point began to say, okay, that's not a yes or no question, to cut it off at the pass, because this business of him not even being given an opportunity to answer the question, and trust me, the Phelps Dunbar attorneys, particularly Ms. Needy, made note of that, but Judge Johnson was reluctant to chide Mr. Price. I would have, if I was the judge, but I'm not the judge. So I found the conduct and like I said, if I were on the jury, it wouldn't be well received. Mr. Price presented some invoices to Mr. Seymour, and Mr. Seymour indicated that, well, those would have had to have been in the work papers of Miss Allen when she, and would have noted them as part of the exam, or filed them as part of her conducting of the exam. He must have reiterated at least 15 times, because he had to, because Mr. Price kept asking questions along these lines, about whether or not these fees that would go from Stanford International Bank into Stanford Group and then from Stanford Group to Stanford Trust were permissible. And he said, look, we told him in 2001 we want an IRS private letter ruling, and all we got was legal opinion. And in his response to either that question or another question, Mr. Price, and in my opinion this is completely unprofessional, and it should be considered an insult to the court, but he said to Mr. Seymour, look, is it your intent to go home before Christmas? Quote, is it your intent to go home before Christmas? Unquote. And of course Ms. Needy immediately objected. But I can tell you of some judges that would not have tolerated that out of any attorney, and I don't think it was appropriate. I think it came across as being a smartass, and if I were on the jury, it wouldn't have gone over well. I'm being blunt with you. Now, as the day wore on, things of that nature kind of subsided, and things became a lot more smoother, and it wasn't herky-jerk, a sidebar every 4 minutes. Thank God, because I don't think any jury would have sufficient patience to deal with that sort of thing throughout an entire trial. So Mr. Seymour wanted to make it very emphatic that we never did approve the payment of those fees. He emphasized that would have been in Miss Allen's records. He stressed that over and over. He was then presented with some documentation that basically showed an itemization of broker by broker, and of course we didn't get to see this. It was not put up on the screen, but going by what the two of them exchanged in their dialogue during his testimony, it was a document that apparently contained about 15 or 20 brokers, the first of which were Jason Green. We've discussed him in quite detail. And then there was an itemization on the document that would contain, I'll get it right in a second, contain the account number and the dates the accounts were opened, and each one had, let's see, it had about 15 brokers according to what I wrote down here. One of them's name was Layfield. I already talked about Jason Green, and who the clients of that particular broker were. And the question was Stanford Trust paying these fees to these brokers? And would that be a prohibited transaction? Mr. Seymour said, look, I'm not certain who paid the fees to the brokers. He said that OFI had made every effort to ensure that the account holders were aware that the fees were being paid to the brokers. And Mr. Price said, well, how would they know if you didn't know? And I'm accelerating through a lot of testimony, but Mr. Price indicated, Mr. Seymour indicated that, well, it should show up, I would assume, on their statement, we would receive, if we had received complaints, we would have investigated, but we got no complaints. He emphasized that on the June 5th of 2008, when the Office of Financial Institutions was invited to Fort Worth, Texas for a meeting with the SEC, the FBI, and the Department of Justice, It was at that point that the SEC revealed that they had had, and he specifically said, a 4-year ongoing investigation into whether or not Stanford was indeed a Ponzi scheme, and they felt it was, they being the SEC, felt it was appropriate to turn the whole matter over to the Justice Department. And as he said, you know, some 6 or 7 months later, everything was shut down. Mr. Price also wanted to grill him, just like he's grilled way back when, in 2012 in her video deposition, Miss Allen, and then again Mr. Ducre yesterday about these SIB CDs being declared to be unique assets. And Mr. Seymour felt, just like the others, that no, a traditional CD should not be considered a unique asset. And I've already covered that in the prior session, so I'm not going to sit here and regurgitate that again, because he echoed their sentiments. I'll just let it go with that. So if you've seen the prior episodes, there's no need for me to elaborate on that. The whole issue of a conflict of interest, Mr. Seymour said was a concern to them, and that there was a potential conflict of interest, and they wanted to do their best to ensure that all of this was an arm's length transaction. And he said we issued this July 21st, 08 letter saying that the OFI was no longer going to accept these legal opinions instead of a private letter from the IRS, and that Louisiana was a, quote, host location, with the headquarters actually being in Texas. But he also stressed that there were other holdings other than these self-directed IRAs. I think yesterday we talked about 72% were concentrated in that, so that's still at least 28% for other vehicles. Mr. Price wanted to grill Mr. Seymour about why there was no ratings downgrade, well, no meaningful one, you know, only from a 1 to a 2 at that final 2007 report. And Mr. Seymour said that one of the biggest reasons is we didn't want to tip off the management, you know, give them any kind of backhanded hint that there may be some improprieties going on here, specifically a Ponzi scheme. And he said he had cleared, or they, the OFI, had cleared the report that they would be issuing with the DOJ before issuing it. Let's see. There was also reference to a February 5th of 07 email involving Deidre Moore, and that was put up on the screen, and it was just one sentence. It says, does management understand that they cannot accept fees for the placement of SIB CDs? Mr. Seymour acknowledged that that had been sent, and then Mr. Price moved on to apparently a directive that was sent out to state chartered banks that said that we are not, this is in 2004, we are not going to allow state chartered banks to invest in SIB, Stanford International Bank, CDs. And so Mr. Price then posed the question. He said, okay, so is it your testimony that while the OFI deemed it to not be an acceptable investment for the state chartered banks, but in your communication that you said that that would be unsafe and unsound banking practice? So he said, well, and I believe that was 4/15 of 04, but do not hold me to that. I wrote a date down of 4/15/04, but it was definitely in 04, so if it's not April 15th, you know, don't come firing the bullets at me. He said, why would you deem it okay for members of the class action to be able to invest in that, but yet the banks, you said they should not invest because it would be considered unsafe and unsound. I'm going to give you the answer that Mr. Seymour gave, and then I'm going to provide the answer I would have given if I had been on the stand and asked that question. Mr. Seymour said, look, you have to realize that these are all self-directed IRAs, and we went on the premise that the trust had no control over the investment decisions made by those self-directed IRA account holders. That's the answer that he gave, and that's certainly a very fine answer. My response would have been that that type of a letter could have, the reason that it is acceptable or can be acceptable for those class members and not for a bank, let me explain something for those of you who are not that familiar with banking. Banking operates on a principle of high leverage, okay? And what I mean by that is that a bank is considered well capitalized if it has what was called a tier 1, but I'm not going to get down that far into the weeds, of 7%. In other words, 7 cents out of every dollar is capital. The remaining 93 cents is in the form of debt. Well, what is that debt? It's deposits. For the most part, it's largely deposits. And so regulators are extremely restrictive of what a bank can put its money in, because if you lose 4 cents on the dollar, you're on the verge of having the door shut, okay? Whereas for a self-directed IRA, there's 100% capital there. So, for example, the OFI could have sent out a letter saying, well, we're not going to allow you to invest in shares of IBM, okay, which a bank cannot, all right? For the simple reason that, well, gee, if shares of IBM drop 20%, you're underwater, I mean, I'm talking about if they put all the money in IBM, but my point is common stocks are not a permissible investment for a bank because there's too much volatility, too much potential for things, and you've got to maintain that capital ratio. And so what is a perfectly acceptable investment for a person like myself will be completely unacceptable for a bank. And so that letter, now the reason no letter like that would be drafted for common stocks is that banks already know they can't do that. He wanted to make clarity here. We are deeming this to be too risky for a bank, but if an individual is content with taking on that risk, that's on them, okay? And that's exactly what Ms. Allen had reiterated, and to a lesser degree, Mr. Ducray. And that is the investment world that we live in, okay? These are self-directed IRAs. If you are comfortable with a ton of risk, have at it. I will tell you that way back in 1987, when leverage buyouts were all the rave, RJR acquired Nabisco. And at that time, it was the largest semi-hostile, well, it wasn't really hostile deal, but it relied heavily on what were called junk bonds, and they were issued and paid interest of 15%. And I said, you know what, I'm going to take a shot, and it paid 15% interest. Now, I only put $10,000 in, and it was in my IRA. It was in my self-directed IRA. But I knew I could lose all of that. I knew it. That's the nature of the beast of a junk bond, and it was a junk bond. It did not carry an investment grade rating. But I was okay with it. I was okay even if I did lose the whole investment. Now, luckily, wound up not losing anything. I got that interest for about 6 years or whatever it was, and then ultimately got the principal. But I said all that to say this. I'm not at all impressed by a question of, so this was deemed okay for these individual investors, but not okay for the bank. I hope I've done a decent job of explaining why I don't think it's any big smoking gun that the OFI issued that letter to its state chartered banks. It's that simple. Mr. Price asked Mr. Seymour if he was familiar with the fact that in 2004 that Whitney had terminated its relationship with Stanford International Bank, saying that we deem it to be basically too much risk, and he indicated that he had not. He also asked him if he was familiar with Graham Thompson. Anybody who's been around banking in Baton Rouge will know that name. Many years ago, he was the president of City National Bank here in Baton Rouge, and subsequently acquired by FNBC. And he was known as an extremely conservative banker. So I assume that Graham Thompson had a role in the letter. I don't know that because I didn't get to see it. But Graham Thompson was known as a very conservative banker, and he was had an outstanding reputation. That was I've hit the high points. There were more. You got to realize questions got asked over and over again. And yes, Phelps Dunbar did object, asked and answered, but Judge Johnson tended to be quite accommodative, in my opinion, in that regard, and allowed that line of questioning to pretty much go unabated. But at any rate, Mr. Seymour's testimony was done by approximately 3:30, give or take, and so now would have ordinarily been the opportunity for cross, but Phelps Dunbar asked to approach, and they had probably about a 4-minute, give or take, sidebar, and when it was over, Judge Johnson indicated that to the jury that, look, we're going a little bit faster than anticipated, and I'm sure the jury thought, well, gee, you could have fooled me. But the bottom line was that they were going to be dismissed for the rest of the day, and that the time that would have been spent yesterday during cross would be utilized today by the defense attorneys to streamline the questioning in order to minimize the inconvenience to the jury. And I heard earlier a projection, we will see if it holds or not, that closing arguments could begin as early as Monday. Bear in mind, Friday, the court has the day off. So if you say, well, gee, I didn't find a whole lot of substance to what you presented today, especially for a gentleman on the stand for as long as he was, you have to realize you have to realize all the sidebars that took place, and well, I've elaborated, so I'm not going to elaborate any further, but just because this video was a little shorter, much shorter than yesterday's, don't read into that things flew by. They most certainly did not. I have no idea what the jury's inclination is at this point. I mean, I literally have no idea. I just gave you my own thoughts of Mr. Price's very unique style in a courtroom. I don't care for it, but what I think doesn't matter. I'm not on the jury. So that's going to do it for today. Tomorrow is supposed to be a full day, and then of course it will be Friday off. So I've had some folk tell me that, hey, we really appreciate this because there's no way we can be there. So for y'all, I'm very pleased to do this. The interest in the general public is non-existent. I mean, it just isn't. And I guess that explains why no mainstream media outlet can even justify being there. There were a few more members in the audience today. I'd say it probably was up to maybe 12. So that was certainly better than yesterday. So hopefully I could try to be your eyes and ears in the courtroom. You had to indulge me for me to express my opinions about Mr. Price's style. If that rubs, if there's plaintiffs that are in the class that have said, well, you got to take the good with the bad when I give I'm going to state my opinion, and I did that. I don't care for his style. So with that, we will bring you in the very near future the fifth segment of the Stanford Investors civil litigation class action lawsuit against the OFI. Once again, this is Robert Burns thanking you for your dedication, and we will see you again very soon. Thank you so much.